The Senate Committee on Civil Rights, Judiciary, and Public Safety is called to order. Will the clerk please call and announce the roll?
Chair Chang.
Here.
Senator Schenk. Here. Senator Voino. Senator Irwin. Here. Senator Santana. Here. Senator Runstead. Here. Senator Johnson. Here. Madam Chair, you have 6 members present. There is a quorum.
Thank you so much. Up next, we are going to resume testimony on House Bills 5148 and 5149. 2 weeks ago, we did have Representatives Grant and Outman come and testify. Picking up where we left off, would like to bring up Rebecca Massey and Stephanie Bush. Rebecca with the Michigan Catholic Conference and Stephanie Bush with the Catholic Charities of West Michigan.
Thank you, Senator Chang and members of the committee. As mentioned, I am Rebecca Massey with the Michigan Catholic Conference. We appreciate the opportunity today to express our concerns in opposition to the House Bills 5148 and 5149. While we recognize the longing that exists to connect with one's birth parents and heritage, following consultation with leaders of our state's Catholic Charities agencies that facilitate adoptions, there is great concern with the legislation, many of which have already been raised in the group letter provided to the committee a couple weeks ago. So I'd now like to introduce Stephanie Bush to help explain the current process and provide some additional context. She is a program manager with Catholic Charities West Michigan and also a confidential intermediary. Stephanie.
Hi, thank you. My name is Stephanie Bush. I have worked at Catholic Charities West Michigan for the past 20 years in adoption services. So working with all members of the triad, adoptees and birth parents alike, both currently that are making adoption plans through that process, but Catholic Charities also holds adoption records back into the 1940s, so we do a lot of post-adoption work, and I handle all of that for all of the Diocese of Grand Rapids, so 11 counties, and all of the adoptions that have been done basically since the 1940s until current. So families, both adoptees and birth parents and biological siblings that approach the agency looking for information from their records, that's just something that I do for the agency. I'm also a court-appointed confidential intermediary, so if either a biological family member or an adoptee approaches a court requesting to have an intermediary appointed to locate someone else in the file that they don't have access to that confidential information, the courts will appoint me to locate that person on their behalf and assist them in reuniting with that person. So that's something I've done since 2015 for various counties across the state. So although Catholic Charities, we really were at the forefront of the open adoption movement in the 1980s and are huge supporters of transparency and openness, we just have some general concerns with the idea of opening up the original birth record. I know that testimony has kind of spoken to the idea that this isn't talking about the adoption record, it's just this one document. But the reality is that in the state of Michigan currently, an adoptee can approach the agency or the courts or the Michigan Department of Health and Human Services directly and request information from either their court or their agency-held record. Currently, regardless of when you were adopted, you can have all of the information from your file with the exception of identifying information, which is really your birth parent's name and the last known address that's in the record. And obviously anything else that would support locating, so the name of the high school you went to or something like that, that might be an identifying piece of information that would also be withheld. So currently, like adoptees will approach the agency, submit information or a request for that, and then we will provide all that information to them. The courts would do the same thing. So the only thing that's not released is the biological parents' names. And we follow a very specific pattern of law to releasing that information. And in the state of Michigan, what that looks like is, again, they referred to the donut in some of the other testimonies, but from 1945 until 1980, during that time period, we can only release a birth parent's name with their explicit written permission. So if they have consented to the release of their information, we will clear the Central Adoption Registry and release that information. And if they have not, then we move people onto the confidential intermediary process. So that's kind of how that flow of information works. After 1980, then it's the flip-flop. So if an adoptee wants their birth parents' identifying information, we check the central adoption registry, and as long as their birth parent hasn't said they can't have it, then we give it to them. So that's just kind of the process right now of how we move people through that. So by the process of releasing the original birth certificate, we're releasing the one piece of information that currently is withheld by releasing the record. So it does make a huge difference for biological parents in that 1945 to 1980 time who have decided for a lot of different reasons not to consent to the release of their information. And again, our hope as confidential intermediaries is always to have that record opened and move that towards a reunion. And if, as a confidential intermediary, if I can't make that happen, then my secondary goal is always to gather as much possible information from the birth parents as I can. So I attempt to get them to still give me a full updated medical history and anything else that they're willing to release if they're not willing to release their name. So that's part of the process of what we kind of do as confidential intermediaries. So one of the other kind of things that popped up was just the idea that, of whether or not birth parents actually have the right to this restriction of access to their information. I guess I just wanted to note that currently in the state of Michigan, when a biological parent goes to court and their parental rights are terminated, they are issued an actual document by the court that is an advice of rights. It's a legal document. And specifically in that it's called Advice of Rights After Order Terminating Parental Rights. It says in there, in addition to the above rights, which explains things like getting a rehearing or appealing a judge's decision, it's saying in addition to those rights, you have the right to control the release of your identifying information about yourself as follows. You may file with the Central Adoption Registry at the Michigan Department of Health and Human Services at any time a form called the Parent's Consent or Denial to Release Information to the Adult Adoptee. With this form, and then it tells them that they can get this form at any circuit court or at the Michigan Department of Health and Human Services. They may consent or deny to the release of the following identifying information: their name at the time of termination of their parental rights, their most recent names and addresses on file at the Central Adoption Registry. They can use the form anytime to change their mind about consenting to or denying the release of this identifying information. So any birth parent that has gone to court and consented to an adoption or released their rights was issued this by the court stating that they had the right to restrict the access to their identifying information. It was a right that they were given at that time. And so we have a lot of adoptees that have gone forward, or a lot of birth parents that have gone forward with that understanding that that was their right, and this would change that for them, which is something that doing a lot of confidential intermediary work I would be concerned about. Adoptions in the 2020s are not the same as people who placed a baby in 45 or 55 or 65. The reasons and what's happened with those birth parents is just very different. A lot of them, it was a very closed system back then. They went on and married and did not, a lot of times their husbands don't know that they placed a child for adoption. Their children don't know they placed a child for adoption, and sometimes it takes a lot of counseling as a confidential intermediary to move someone through that process of opening up to now telling these people in their life that they placed a baby and then welcoming the adoptee into their life with grace and joy. But that's like something as an intermediary that we do. We help them move through that process. But a lot, there are times that I can't get them to move through that process because nobody knows and they don't want anybody to know. So that's just kind of a piece of that intermediary process. So I guess the last thing I would want to say is just, so obviously at the birth of a child in an adoption situation, an original birth record is created, listing the birth mother's name on the record as well as the original name of the adoptee. That goes to the Vital Records Office. When the second birth certificate is issued at the time that the adoption finalizes, which is currently it's maybe about 3 to 5 months later. Back in the 1950s, it could have been up to 2 years later by the time that adoption finalized. A new birth record is issued. The first birth record becomes a historical document, meaning it cannot be used for any official purposes. If you were able to obtain that, it would have historical stamped all over it because they don't want it out there being able to use to obtain a passport or a driver's license because they're different names. It's why one of the reasons why the Vital Records Office restricts that. So that second birth record is the one that is available to the adoptee to use for like passports and other things. As agencies, we also help people navigate that process if they need to get a passport, to get Native membership in a Native American tribe or something like that. So I think one of my concerns is that having access to records from the 1940s to current is that generally, and even today, the birth mother's name is the only one that went on that adoption record. So if an adoptee is getting access to their adoption record, or to this original birth certificate, the birth father still gets to keep his anonymity. His name is in the record, in our records, but it's not going to be on the birth certificate. So it kind of creates an inequity in that. The other inequity that I worry about is that we don't just have adoptees come forward looking for information on their birth parents. We have birth parents that come to us looking for information on a child they placed for adoption, or a biological sibling coming to us asking for information on a child that their parents placed for adoption. The adoptee's information is still completely confidential. It can never be released to the birth parents, ever, without their explicit written permission. So it's this thing where we're going to take that right away from the birth parent. They will no longer have the right to confidentiality, but the adoptee still does. And they always will. That doesn't even expire upon their death. So I've had adoptees that have passed away and a birth parent searching for them. And if they've passed away, we can never release that information to them. So it just kind of creates this inequity of like, the birth mother's name is the one that now will be released and everybody else gets to still remain confidential in that process. So I just kind of worry about the kind of inequity in that for both birth fathers and for the birth mothers looking for their child, who has the equal right when I contact them to say, I don't want anything to do with this and I do not want you to give out my name to my birth parents. They'll still continue to have that right. So yeah, I guess that's generally all I had to say. So,
Thank you. We'll be open for any questions.
Okay, thank you. How does someone become an intermediary? Or do you have to get licensed or something through the state? How does that work, and how many are there? Do we know?
There's not a lot. So the state actually only ever has done 2 trainings that I'm aware of for confidential intermediaries. The last one was in, I think I said 2015, I think it was actually in 2017. So the state of Michigan held a training where they brought people in and trained them on how to do this. After that, you take your certificate from the state to the actual county court, and then you swear in as a officer of the court. Because you're handling the court's confidential documents, we have to actually be sworn in. So there's probably not a ton. I mean, in the county, so when I do it in Kent County, I think there's 2 or maybe 3 in all of Kent County. Some counties, I'm the only person that does it. There are not a lot of confidential intermediaries. So. Probably plenty we don't get so many of them that we can't get through all of them though. So.
Okay.
But yeah.
We have a question from Senator Runstead.
Thank you, Madam Chair. You identified, I think, a lot of the concerns I had, that these parents many, many years ago, decades ago, were under the understanding, and we did discuss that in the previous hearing, they were under the understanding there is a form that they signed that they were under the understanding that this was not going to get disclosed. So we're now changing this contract years later. And I can think, as you were talking, in my extended family, there was a case of the oldest daughter had a child, and she was kind of not in the best situation to be raising the child. So the grandparents adopted, and that was never disclosed to anyone. Nobody knew the details. And years later, it got unearthed, and it created a hell within the family. I mean, it was in another state, but these were all cousins, and it just ripped family relationships to shreds more than you could ever anticipate that something like that would cause that problem. But it did, and still lasts to this day. So there's a lot of unintended consequences that I see people just wanting to ignore and pertaining to this bill. Thank you for your testimony.
Thank you. Question from Senator Irwin.
Yeah, I was just wondering if you, based on the work you've done, have any commentary on the effect that 23andMe, Ancestry.com, all of that is having on your world. Are you seeing cases where folks are either coming to you or, interacting with, folks that are, I guess in your files, for lack of a better way of putting it, because of information that they've acquired privately?
Yeah, absolutely. So I would say that, in the last 10 years, a lot of times when somebody calls ready to kind of do searching out of their records, they have already done some sort of Ancestry.com or 23andMe. Sometimes it's brought them a very clear answer, and they've approached them, family members on their own. A lot of times it doesn't, though. Sometimes it gets them into a vague family tree. And so they're kind of hoping that maybe something I give them will tip them off to more information. I always encourage, families, if they're willing to go through the confidential intermediary process, it's going to 100% get them an answer. They're going to, it might be the answer that the person won't disclose information to them, but I will find their birth parent and we'll find out if they're, willing to disclose that information. But yes, it's definitely becoming part of what a lot of adoptees are going through. And I definitely encourage them at times to, to seek that information, especially, because it absolutely is part of it, 100%.
Just as a brief follow-up, what do you make of the argument that because of those resources, people who are seeking out their birth parent are going to cause more consternation and frustration for families as they call everybody in that family tree trying to get the information they want rather than, getting it directly through a bill like this?
So saying that they would have their birth parent's name instead of calling every aunt and uncle before they get to the birth parent?
Correct, and that may cause less frustration, consternation, violation of privacy.
Yeah. I could understand that. I think that that's true. But I also think that it's the same thing with us. It's going straight to the source. We're going to go to the birth parent with good information, 100% knowing that it's legitimate. I get a lot of birth parents calling me in panics because someone's reached out to them and they're scared it's a scam. They don't know if this is real. They're kind of panicking about this, where when I call them from, I'm Stephanie from, 1965, you worked with the Catholic Services Bureau. This was your name at the time. They're 100. They know that this is legitimate, so they know that I can legitimately walk them through that information. A lot of times, especially if somebody's elderly, this is very scary for them. Even if it came directly to them. So there's process to all of that. Every human being reacts very differently, and as a confidential intermediary, I get a myriad of responses that I can't even explain, from people hanging up on you to people who are absolutely thrilled that somebody's finally reaching out to them, and everything in between. I'm sure it's the same way if someone reaches out directly.
If I could also just add on to that too, I think there is concern with, obviously 23andMe is something that's come about, more recently, but there's also sort of the information, the changing what the state has been, sort of the people's sort of expectation of what they're receiving from the state and changing that retroactively. And thank you.
There's a question from Senator Johnson.
You just hit on part of it. As I understand it, more and more crimes are being solved because of 23andMe and I think there's one other big company, because once they find a relative that matches the DNA, sometimes that helps them in solving a crime. How would 23andMe and people finding information, how would that dovetail with what you're working on?
Well, I think it's totally separate, right? So 23andMe is a private, organization, a private company, and what we're talking about is changing the process of what the state, information that the state has, and we want to make sure that the state's sort of the expectation that the state put out there for adopted parents remains.
Okay, thank you very much. Up next, we have Katie Page Sander, who is the Executive Director of Hands Across the Water. Also, just a note for members, I know that originally we were planning to end at 1:30. I will stay, and whoever else is able to stay, feel free. And then also, I know others have committees, so feel free to also leave when you need to. Thank you. There's a little button at the bottom of the microphone.
Okay.
You got it. Thanks.
All right. Thank you, Chair Chang and members of the committee for the opportunity to speak on House Bills 5148 and 5149. My name is Katie Page Sander, and I'm from Ann Arbor. I come before you today as an adoptive parent of two, the spouse of an adoptee, and as a child welfare professional with 27 years of experience working with children and adults in the adoption triad. I'm also currently on the board of directors of the Michigan Federation for Children and Families, which includes 60 member agencies serving children and families across all 83 counties in Michigan. We are the issue area experts on adoption policy and have submitted a letter of support for these bills. I am also the executive director of one of these member agencies, Hands Across the Water, a private nonprofit in Washtenaw County licensed in the state of Michigan to evaluate applicants for adoption and to place and supervise children for adoption. Our agency in Ann Arbor has been there since 1999, and we have placed over 1,200 children in adoptive homes through intercountry adoption, direct placement, infant adoption, and the adoption of children from the child welfare system. With this expertise, I am extremely disappointed in the opposition that has come out against these bills, which I believe to be based on misinformation about the adoption process and how this bill's passage would negatively impact the privacy and safety of birth parents. Opponents of these bills fail to acknowledge some hard truths. The practice of amending birth certificates, which began in the 1940s, was a strategy to prevent birth parents from interfering with their child and the adoptive family, not to protect birth parents. New falsified birth certificates allow adoptive parents to keep their child's adoption a secret if they choose, which we now know is a terrible practice, as described by one of the senators. In 2006, when I adopted my son, a new birth certificate was created that makes it appear as if I had given birth to him in Portland, Oregon, a place that I had never lived nor even traveled to. 2, when a birth parent relinquishes their rights or their rights are terminated involuntarily, there can be no guarantee to that parent that the child will be adopted. Because of this fact, there can be no guarantee made by the agency, the court, or the state of Michigan that a new birth certificate will be created, the original sealed, and the birth parent's name held secret. Finally, birth parents are not given a promise of lifelong anonymity. In fact, many birth parents are wrongly informed that their child will be given free access to their birth record when they turn 18. Additionally, unethical agencies have historically used coercive practices to shame and silence birth parents, telling them that their child will be better off not knowing them, and that they are performing a selfless act by giving a deserving couple the gift of a baby, ultimately discouraging openness as confusing or detrimental to the child. This bill, unlike current law, actually provides agency, empowerment, and protection for birth parents and adoptees alike through the contact preference form. The use of that form, along with the bill's educational awareness program, empowers all people impacted by the bill. This is considered best practice today, particularly when DNA testing has become so widespread. Doing nothing and continuing to restrict the release of the birth record simply perpetuates stigma and often leaves the birth parent with much less of a guarantee of privacy around their adoption decision, as multiple family members are alerted to the DNA match of the adoptee. Family group chats may read, "Which of our aunts and uncles had a baby in 1975?" In the case of a rape or assault, an adoptee may unknowingly reach out to the assailant or their extended family members. Instead, the release of a single vital record with an attached contact preference form is far more effective in achieving the goal of privacy for a birth parent. As an adoptive professional, an adoptive parent, and an advocate for both birth parents and adoptees, we must do better. Our state laws have allowed for a culture of shame and secrecy to continue to surround adoption, which is not only harmful to adoptees, but to birth parents. All adults deserve the right to determine what type of relationship they have with another person. With the passage of these bills, birth parents will continue to be free to tell their adult children that they relinquished that they are not interested in contact. But no person, parent or not, should have the right to restrict another person's civil right to their vital record. Thank you for the opportunity to speak, and I ask that you correct Michigan's outdated and discriminatory law by passing these bills. Thank you.
Thank you for your testimony. Any questions from committee members? Okay. Up next, we have Genevieve Marnin from Right to Life, Michigan.
Madam Chair, members of the committee, thank you for giving me a few minutes to speak about House Bills 5148 and 5149. My name is Genevieve Marnin, and I'm the Legislative Director for Right to Life of Michigan. Right to Life of Michigan has been advocating for adoption for over 50 years and has been instrumental in adoption law for decades. We were intimately involved in the change to the adoption law in 2014, which streamlines the adoption process and allows for direct placement adoptions. In addition, Right to Life of Michigan has advocated for the choice of birth mothers and parents to utilize the adoption process that best suits their particular circumstances, whether that's an open adoption, a closed adoption, or in the rare circumstance, the delivery of a newborn to a safe delivery law. I'm here to voice my concerns with and opposition to House Bills 1548 and 1549. Collectively, these bills will upend adoption confidentiality and open birth parents to potentially unwanted interaction with now adult children whom they placed for adoption perhaps decades ago. A lot of this you guys just heard. I think that the previous two testimonies ago about the confidentiality intermediary was excellent, so I probably won't bog you down with all of that, but there is a process in place should parents want to reunite or the adult adoptee wants to reunite. But it respects the fact that in some circumstances, that's not necessarily a good idea. These contracts, if you will, were submitted to and approved by the Court of Law in the state and should be given the guarantee that those contracts will be honored and not changed without the agreement of the parties. Now, even changing the law such that the language is prospective rather than retroactive is still problematic. Most adoptions, most infant adoptions today are open adoptions. That's the vast majority are. There are very few, but there are some that are still closed adoptions. And those are usually due to circumstances such as family dynamics, abuse, threats, or even celebrity status. And I'm going to stop here and tell you a story. This just happened about 10 years ago. There was a young woman who was impregnated by a very, very dangerous man. And he was trying to get her to have an abortion. She didn't believe in abortion, so she contacted us and said, "What do I do?" And he threatened her, and he said, if my name is ever, quote, if my name is ever associated with this child, I will destroy you. For her, a closed adoption was imperative. And the fear that someday she could be discovered and he could be discovered is terrifying. Again, these are rare circumstances, but for those rare circumstances, I think we need to think twice about giving out these birth records. When women make these choices to place their baby for a closed adoption, breaching this agreement by opening the birth certificate to now adult adoptees is wrong and potentially dangerous. The current law is good. It provides protection, yet a potential connection without jeopardizing those who made the decision for a closed adoption and who were promised an anonymity. I do appreciate the concept of giving adult adoptees access to their original birth certificates so that they know and understand their genetic background. But you can imagine the chilling effect this change could have on the infant adoption process, which is already very, very rare in our state, and the profound impact this could have on those who've already placed a child for adoption. I do urge a no vote on House Bills 1548 and 1549. Thank you.
Thank you. Any questions from committee members? All right. Up next on Zoom, we have Lisa Johnston.
My name is Johnson. I'm a mother of 4 and a 2 and a Christian. I'm also a survivor of rape has placed 2 children for adoption. First, I say that I'm misrepresented by the organization that passes bills. Let me be clear. I wholeheartedly endorse the passage of HB5148 and 519. In 1998, after a very brutal rape, I learned I was pregnant. At the time, I felt that adoption was the only logical choice for me and my son. As an expectant mother, I could not bear to risk that his life would be hindered by the damage that had done to me. No child deserves that risk. It would be several years before I felt whole and fully able to see him as a person separate from me. People have told me over the years why they believe I need to be protected from my own children, and each of them has been wrong. I have yet to hear any accurate information based on the needs and experiences of my own or other birth parent situations. I have also rarely experienced a genuine concern about birth mothers like me from anyone who hasn't placed a child. Birth mothers deserve a basic level of control over their own expectations and needs with respect to the degree of contact with our adult children. With DNA testing and other options like private investigators, adoptee search angels, and adult adoptees holding signs on social media asking for help, there are already adult adoptees searching and having success, even with a sealed, unavailable record. Reality is that restricting adults from holding their own birth records ensures far less privacy and creates far more chaos and unpredictability for the birth mothers the opposing organizations are claiming to protect. I ask that we stop ignoring reality and calling this attempt to limit access a protection for birth mothers like me. Please listen and act on the actual experience of those who have actually placed a child, because we found ourselves pregnant after a rape. If you ignore our reality, we are left with contact to be made through a DNA test match, social media, or by a search angel specializing in adoptee searches for birth parents. Are these the most private or considerate options for contact? Absolutely not. Birth parents like me do not want a random, unpredictable, or unintrusive inquiries into our history or decisions. We want the security to share contact preferences with our adult children and the option to share details of a placement on our own terms. The options, including indicating a birth parent may not want contact at all. As a birth mother to 2 adult children, I support their rights to original birth record. As a rape survivor, I pray that you listen to all birth mothers who have surrendered their children to adoption, but especially those like me who have placed a child conceived through rape. Others who are trying to tell you what we need and want are not speaking from my reality. Please support these bills because they create the most private, safest options for all birth parents, victims of rape, and their adult children, because a DNA test is not any of those things. I am open to any questions you may have about my experience.
Thank you, Lisa, for sharing. We appreciate your testimony. Any questions? Okay. And then finally, we do have Jennifer Grayheck. Apologies if I mispronounced that, from the Family Law Section Adoption Subcommittee.
Yes, thank you so much. This has been a fascinating experience for me. I didn't know all about the confidential intermediary program, and that testimony was awesome. I loved listening to it. As you may know, my name is Jennifer Grahek. I am a member of the Michigan Adoption Subcommittee, and we as that subcommittee, we do oppose the bills as they are presented. We do also see that an adult adoptee should be able to get their birth certificate if they go through the process. And right now that process is well in hand in the code. Currently, they can get a certificate if termination of parental rights occurred between the years of 1948 or 1945 through 1980, which we wouldn't be opposed to getting rid of those years. The rights were not terminated pursuant to the juvenile code, and the parent or parents are living and do not have a form on file with the MDHHS, because sometimes those parent consent denial forms, those are voluntary by the birth parent, either mother or father, to file. So sometimes those don't get filed because they don't want to do it, or something occurs where they don't update it and don't send it. We understand that. But an adult adoptee can obtain a court order overcoming those obstacles if they file a motion with the court based on good cause. And good cause is always up in the air, and I can't define it. A lot of it is situational. House Bills 5148 and 5149 appear to permit a much broader access to the original pre-birth pre-adoptive certificate to not only adult adoptees, but also to their descendants or legal representatives of the adult adoptee. We feel that is too broad and doesn't take into consideration a birth parent's expressed denial of a release of public information. It also does not require confirmation. The bills as written don't require confirmation that the adult adoptee would want a descendant or a legal representative to have their birth certificate. And it also permits release of adoption records older than 100 years. I think if those adoption records were sealed at the time, I don't think you should change that and open those adoption records, even if it's over 100 years. We would request as a subcommittee that birth certificates only be available to adult adoptees if there's no express denial or release of identifying information, or if the parent is deceased. The birth certificates may also be released to a descendant or legal representative if the adult adoptee has provided some written authorization, maybe in their durable power of attorney, if they have a legal representative allowing to get that information. We just don't want the way that the House bills are written is that there's a written request and you pay the fee. There's nothing indicating in between there what is the backup of that. Who is the descendant? What was the date of death of the adult adoptee? Can you provide a death certificate? It doesn't seem that the steps are in there to what goes in with that written request. That would be my where I would see what are some additional steps needed for a descendant of an adult adoptee or their legal representative to get that. If they have it in their will, hey, I want my personal representative to, here's my information, I was an adult adoptee, if you could get my birth certificate prior to my adoption, that would be great. I give you authorization. And that could be built right into EP planning. But right now, it just seems that a lot of things are being circumvented for the birth parent. And if they went into an adoption with the understanding that their information remained confidential, then we should honor that. And if there are steps through a confidential intermediary, those steps are in place for a reason. And I think that's what we should focus on, and not just allowing a written consent or a written authorization with payment of fee. That is basically the Michigan Adoption Subcommittee's position on that, and I'm open up to questions. If I can answer them, I will.
Thank you. Do you have, if you have written recommendations, because it sounds like you had a couple of specific suggestions, if you could provide them, that would be really helpful so that we can take a look.
More than happy to. I would just need to know where to send it. I believe we tried to be in contact with the family law section. So those my comments might already be with them, but I will put out the word that you would like those specific things either emailed or sent to you. I'd be more than happy to do that.
Great, thank you. Any questions? Okay. We do have some cards, I think.
Yes, we do, Madam
Okay.
Chair. Not wishing to speak in support of House Bills 5148 and 49, Daryl Royal, representing Michigan Searching Facebook Group. Not wishing to speak in support of the same bills, Valerie Lamar, representing Michigan Adoptee Rights Coalition. Not wishing to speak in support of both bills, Dr. Rebecca Hansen, representing Michigan Adoptee Rights Coalition. Not wishing to speak in support of both bills, Laura Overset, representing Adoptee Advocates of Michigan. Not wishing to speak opposed to both bills, Jess Averill, representing Michigan Domestic and Sexual Violence Prevention and Treatment Board. Additionally, providing written testimony, Elise Lewis, President, Louisiana Coalition for Adoption Reform, in support of both bills. Gretchen Wiebel, representing herself in support of both bills. Multiple groups: Concerned United Birth Parents, Mothers for Open Records Everywhere, Catholic Mothers for Truth and Transparency, Saving Our Sisters, and First Mother Forum, in support of both bills. Richard Urlab, President, Coalition for Truth and Transparency in Adoption, supporting both bills. Academy of Adoption and Assisted Reproduction Attorneys, in support of both bills. Richard Hill, representing himself, in support of both bills. And Lorraine Dusky, founder, First Mother Forum, in support of both bills. All of this written testimony was provided to the members, Madam Chair.
Thank you very much. We know that there are we really appreciate everyone's testimony when we know that there is a problem to be solved, and obviously a number of folks who have concerns. I'm hopeful that we can figure out a way to move this forward in a way that also resolves some of the concerns. So would encourage folks who have concerns to share specific suggestions, and we will consider them. So there being no further business, the Senate Committee on Civil Rights, Judiciary, and Public Safety is now adjourned.